guys, I'm Berbet Christy B. Bersaliano, and I will discuss the case number 1, which the title is Pulache et al. Versus ABS-CBN Broadcasting Corporation. Pulache et al. Is the petitioners, and ABS-CBN Broadcasting Corporation is the respondent, dated January 21, 2010. I will discuss first the facts. Petitioners, who are the drivers, cameraman, editors, respondents of ABS-CBN, filed a complaint about regularization, unfair labor practice, and several money claims against the latter. The petitioners alleged on December 17, 1999, ABS-CBN and ABS-CBN Rank and File Employees Union executed a collective bargaining agreement. However, they were excluded as coverage of ABS-CBN and considered them as temporary and not regular employees. They claimed that they had already rendered more than a year's service in the company and therefore should be considered as regular employees entitled to security of tenure and to the privileges and benefits of irregular employees. They also asked for to be paid by overtime, night shift differential, service incentive leave pay, holiday, and rest day. They also prayed for an award of moral damages and attorney's fees. Leading to ABS-CBN as talent petitioners, considered them as independent contractors that are paid or pre-arranged consideration called talent fees taken from the budget of a particular program. They do not undergo probationaries, that their services are engaged for a specific program or production, and their contract is terminated once the program or production is completed. On January 17, 2002, labor arbiter Renduque rendered his decision that the petitioners are regular employees of ABS-CBN and not independent contractors. They also entitled to benefits and privileges of regular employees. While the appeal of regularization was pending, ABS-CBN dismissed Fulache Habonero, Castillo, Lagunsad, and Atinen, which is all the drivers, for refusal to sign up contract of employment with service contractors, ABLE Services. The 4 drivers responded by filing a complaint of illegal dismissal case. In defense, ABS-CBN alleged that even before the labor arbiter decision on January 17, 2002 about regularization case, it had already undertaken a comprehensive review of its organizational structure to address its operational requirements. In April 21, 2003 decision in the illegal dismissal case, labor arbiter Renduque held the validity of ABS-CBN contracting out of certain work or services on its operations. The labor arbiter found that the petitioners Fulache Habonero, Castillo, Lagunsad, and Atinen had been dismissed due to redundancy and authorized causes of the Labor Code. The NLRC reversed the labor arbiter's ruling in the illegal dismissal case. It found that the petitioners had been illegally dismissed and awarded them a separation pay and back wages in lieu of reinstatement. Petitioners filed a petition for certiorari before the Court of Appeals, contending that the NLRC committed grave abuse of discretion in denying them benefits under the CBA. On the illegal dismissal issue, the Court of Appeals upheld on the NLRC decision, holding that Fulache Habonero, Castillo, Lagunsad, and Atinen were not illegally dismissed, as their separation from the service was due to redundancy. The second is the issue. There are 3 issues in the case. First one is whether or not the petitioners are regular employees. Second, whether or not the petitioners are entitled to CBA benefits. Third one is whether or not the petitioners are illegally dismissed. The last one is the ruling of the case, and I will discuss first is the petitioners were regular employees because they were engaged to perform activities that are usually necessary or desirable in ABS-CBN trade or businesses. They cannot be considered contractual employees since they were not be paid for the result of their work but on a monthly basis and were required to do their work in accordance with the company's schedule. The petitioners were awarded CBA benefits and privileges from the time they become regular employees and up to the time of their dismissal. The regularization case was in fact the root of resulting bad faith as this case gave rise and led to dismissal case. In the course of this appeal, ABS-CBN took matters in its own hand and terminated petitioner services and disregarding its own appeal and then pending with the NLRC. To justify the termination of service, the company cited redundancy as its authorized causes but offered no justificatory supporting evidence. It merely claimed that it was contracting out the petitioner's activities in the exercise of management prerogatives. ABS-CBN forgot the labor law claiming redundancy as authorized causes for dismissal. It impliedly admitted that the petitioners were regular employees whose services by law it can only be terminated by just and authorized causes defined under the Labor Code. Likewise, ABS-CBN forgot that it had an existing CBA with a union whose agreement must be respected in any move of affecting the security of tenure of affected employees. Otherwise, it ran the risk of committing unfair labor practice, both criminal and administrative offense. Similarly, forgot that an exercise of management prerogative can be valid only if it's undertaken in good faith and with no intent to defeat and circumvent the rights of its employees under the laws or under the valid agreements.
Good day everyone. For our next case, we have Mr. Paul B. Santiago as the petitioner versus Sharp Crew Management Incorporation as the respondent, dated July 10, 2007. For facts, Mr. Paul had been working as a seafarer for Smith Bell Management Incorporation for 5 years. He was contracted by Manning Agent, which is the Sharp Crew Management Incorporation, as on February 3, 1998. Which is the contract was approved by POEA to be deployed on board the MSBC Spread, which was scheduled to leave for Canada on February 13, 1998. But a week before his departure, the MSP captain received a message from respondent's BP saying that he received a phone call from Paul's wife saying that she will not send her husband to MSP anymore, and another call from unknown person saying that if Paul allowed to depart, he will jump ship in Canada. And so on February 9, 1998, Paul was told that he will be not leaving for Canada anymore. And so, Mr. Paul filed a complaint for illegal dismissal, damages, and attorney fees against the respondent and its foreign principal. Labor arbiter ruled that the employment contract was remained valid but did not commence since the petitioner was not deployed. But labor arbiter held the respondents liable. On appeal by respondent, the NLRC ruled that there is no employer-employee relationship because under the POEA standard contract, the employment contract shall commence upon um, actual departure of the seafarer, and in the absence of this employer-employee relationship, the claims for illegal dismissal, damages, and attorney fees should be dismissed. So, NLRC found out the respondent's decision not to deploy Mr. Paul was a valid exercise of management prerogative. So, Mr. Paul, the petitioner, elevated the case to the Court of Appeals through certiorari. Appellate Court, it agreed with the NLRC finding that the petitioner non-deployment was a valid exercise of management prerogative, and it added that since Paul had not deployed, no employee-employer relationship arose, and any claim for damages is impossible. So, as per issue, the issue is whether or not employer-employee relationship has already commenced between Mr. Paul and Sharp Crew Management Incorporation. For ruling, there is no question that they both entered into a employment contract. The distinction must be made between the perfection of the contract and the commencement of employer-employee relationship. As per the perfection of the contract, they both agreed in the object and the cause, and as well as the rest of terms and conditions therein. So, as per commencement of employer-employee relationship, it does not happen because of non-deployment of Mr. Paul. So, thus, even before the start of any employer-employee relationship, the perfection of the contract was made. So, there is a birth of certain rights and obligation, where the breach of which may give rise to a cause of action against the erring party, which is the Sharp Crew Management Incorporation, as they breach the contract by not deploying Mr. Paul. As per its ruling, the petition is granted in part. Court of Appeals decision are reversed and set aside, and labor arbiter's decision is reinstated with the modification that respondent, Sharp Crew Management Incorporation, is ordered to pay actual or compensatory damages to Mr. Paul. So, as per the issue, whether or not employer-employee relationship has already commenced, no. There is no employer-employee relationship commencement since Mr. Paul was not deployed. That's all.
Good day everyone, I'm Daniela Ann Molon. I will be discussing the last part of our case entitled Marsman and Company Incorporation, the petitioner versus Rodil C. Santa Rita, the respondent, dated April 23, 2018. So, the story started when Marsman was engaged in the business of distribution and sale of pharmaceutical and consumer products for different manufacturers. Then, Marsman temporarily hired Santa Rita from November 16, 1993 as a warehouse helper, then confirmed his status as a regular employee on September 18, 1994 with a monthly wage of 3,796. So, Santa Rita later joined Marsman Employees Union or MEU. So, Marsman initially administered Santa Rita's warehouse assignments to its different warehouses. After that, July 1995, Marsman purchased Metro Drug Distribution Incorporation, now Consumer Products Distribution Services Incorporation or CPDSI, which was also engaged in distribution of pharmaceutical and consumer products. Then, the similarity in their businesses led to the integration of their employees formalized in the Memorandum of Agreement dated June 1996, which provides that the management decided to integrate the employees of Marsman and Metro Drug effective July 1, 1996 under the Metro Drug legal entity, and that the union acknowledged management decision to transfer all employees of Marsman, including members of Marsman Employees Union, to Metro Drug Distribution Incorporation. Then, CPDSI contracted its logistics services to EAC distributors or EAC, where CPDSI would provide warehousemen for EAC's tobacco business operating in EAC Libby's warehouse. Then, a letter issued by Marsman confirmed Santa Rita's appointment as warehouseman for EAC's Libby's warehouse effective October 13, 1997, which also stated that the assignment was a transfer that is part of our cross-training program.
Good day everyone, I am Joanna Lynn H. Rodosio. I am discussing the continuation of the case. So, EAC ended their logistics service agreement with CPDSI due to the transfer of its stock to its own warehouse. So, CPDSI thus terminated the employment of those assigned in the EAC Libby's warehouse, including Santa Rita. In a letter, CPDSI's VP notified Santa Rita that his service will be terminated on February 28, 2000 due to redundancy. So, CPDSI also reported this to DOLE. On January 25, 2000, Santa Rita filed a complaint in the NLRC against Marsman for illegal dismissal with damages in the form of moral, exemplary, and actual damages and attorney's fees. So that Marsman filed a MTD on the premise that the labor arbiter had no jurisdiction over the complaint for illegal dismissal because Marsman is not Santa Rita's employer, and that labor arbiter found out that Marsman was guilty of illegal dismissal, and NLRC reversed upon appeal, finding that there was no employer-to-employee relationship. The Court of Appeal reversed the NLRC and held that Marsman was Santa Rita's employer because he was allegedly not part of the integration of employees between Marsman and CPDSI. Hence, this petition is by Marsman. So the issue here is that whether or not an employer-to-employer relationship existed between Marsman and Santa Rita at the time of the latter's dismissal. Although this court is not a trier of facts, it is a constraint to wade into factual matters when there is insufficient or insubstantial evidence on record to support those factual findings, or when too much is concluded, inferred, or deduced from the bare of incomplete facts appearing on the record.
Good day everyone, I'm Lay Irish Maigting. So I'm the last reporter The ruling was here Santa Rita failed to satisfy the fourfold test, which determined the existence of an employer-employee relationship. So the first one is the power of selection. There was nothing in the agreement to negate CPDSI power to select its employees and to decide when to engage them. So the second one is the payment of wages. The Form 4 leave application bearing Marsman's logo did not sufficiently establish that Marsman paid Santa Rita's wages. He could have presented pay slips, salary vouchers, payroll certificates of withholding tax on compensation, income, or testimonies of his witnesses. So the third one is the power of dismissal. The latter dated January 14, 2000, clearly indicated that CPDSI and not Marsman terminated Santa Rita's services. So lastly, the power of control. The court has held in a business establishment, an identification card is usually provided not only as a security measure but mainly to identify the holder thereof as a bona fide employee of the firm issuing. So that's all. Thank you.